And in every case, it's 8 for Senk. Each party will have 15 minutes to present their argument. Counsel, do you know how long you would like to reserve for rebuttal?
No more than 3 minutes, Your Honor.
Okay, I'll note 3 minutes. As you're at the podium, if you look to your left, the time is up there. I'll be keeping it. I'll try to let you know when you're about a minute left in your time.
Thank you.
If you go over your rebuttal time, or your time will just go off your rebuttal time. So if you talk for 14 minutes, you'll just have 1 minute left for rebuttal.
Thank you.
And when you look up, please again, look at the top one, you'll see that countdown in your mind. When there's 3 minutes left, that's when you would like to be stopping for your rebuttal.
Thank you.
The arguments are being recorded, so when you come up to the podium, please stay behind the podium because we're visually recording you, and also speak loud enough so we can hear you. If you move around, we can lose you sometimes, so we appreciate that. You should not use the name of any child, minor, or victim. In this case, I don't know that really applies in this particular matter, but if it were, don't use the name of a child, minor, or victim. With that, the courts have read your brief and are ready to proceed whenever you are.
Thank you. I will approach. Good morning. Attorney Donald Pond on behalf of Appellant Joseph Senk. May it please the Honorable Court, Mr. Senk has asked me, instructed me to appear here this morning in what we hope is not a quixotic endeavor. Nonetheless, he concedes the conviction that it was within sufficiency and manifest way of the evidence, so those matters were not argued in the brief. Instead, Mr. Senk, appellant, has asked that I work on his behalf to attack and ask this court to overturn the fine or remand it to the trial court for reconsideration of whether the fine should be imposed. We relied primarily on the pre-sentence investigation in appellant's brief because that is the last document that was before the court before sentencing. And that is the document that clearly spells out Mr. Senk's health issues and his poverty. He cannot afford to pay this fine, but yet it hangs over him as a condition of his community control. Certainly the court imposed the minimum prison sentence of 2 years and suspended that sentence, had Mr. Senk serve 90 days in jail, and then the monetary fine was imposed as a condition of community control. So while he did not go directly to prison, if he violates community control in some manner, one of which can be to not pay this fine, then he eventually could go to prison. And I know that a community control violation, he understands that community control violation is a matter for resentencing, but we do not want to leave this issue unargued at this level and have a potential waiver of the actual fine later if that's
Under this statute, if
yes.
the court were to find he's indigent and could not pay the fine, will they be required to send him to prison under the either they shall fine him $10,000 or they shall submit him to at least 2 years in prison?
Well, I believe in the state, it doesn't, it's not, and I know that Title 37 is not Title 29. In Title 29, there are mandatory prison sentences. Here, the word mandatory is not used. So,
No, it seems to lengthen the statute. It says you shall have a fine of $10,000 or you shall be sentenced to prison. So it would seem to me if you were to say this person can't pay a fine, at least it's arguable to say that, well, the only option the trial court had at that point would have been to send him to prison, which with the PSI was not a particularly good option in this case.
right. But it does not say that he could be jailed it uses the word imprisoned. So going to ODRC, the Ohio Department of Rehabilitation and Correction, is a different sanction than jail. It has different implications, having a prison number, an ODRC prison number on your criminal history for the duration of your life. So the court jailed him. So that potentially, we would argue, would be a potential sentence of jail time or local. I just think without the word mandatory in there, and there's not, shall does not always, and we didn't brief this, but shall does not always mean shall. There are limited circumstances where it means may. But I think given that the court imposed a 90-day jail sentence, that prison would not necessarily be imposed, that there were other sanctions.
You didn't specifically object to the jail time, I take it. In your appeal, never mentioned the court's erring by sentencing him to jail. Is that fair?
Correct. And we looked at the factors for excessive fine and the gross disproportionality. And we understand that, and I think the state would agree with this here, that we're on a plein air review in that the trial counsel did not object to the fine. The state's brief stated that it may have been a sound trial strategy from trial counsel to argue for a fine rather than the imposition of sentence, and that was a matter that was discussed, possibly was discussed. There was an implication that it was discussed between trial counsel and Mr. Senk prior to sentencing based on the sentiments expressed to the court by trial counsel. But there's 8 factors for gross proportionality. We concede there's a lot of tires, but by the same token, he's a one-person operation with maybe a couple part-time helpers here and there. It's hard to quantify what the financial gain was. There were a couple exhibits for receipts of $150 to haul away the tires, $50, $75. So in appellant's view, this is a small-time operation. And
the state cites numbers of like 20 or 30,000 tires being found. Is that fair in the record, that if you look at the trial record and everything else, that there was a substantial number of tires that he had received over the years?
I went through the exhibits prior to the briefing, and I went through the exhibits prior to oral argument. I see a lot of tires, but I don't see anywhere near 20 to 30,000 tires. And there's no evidence that all of those tires that were stored at a couple of locations were placed there by Mr. Senk.
Counsel?
Yes.
Doesn't the record reflect that he actually rented that warehouse though?
Yes.
And
yes.
so you could presume that all the tires were in his least constructive possession.
Well, yes, we would.
And they said the warehouse was full of tires.
Yeah, yes. And there were some tires in a semi-trailer, and surrounded semi-trailer location too, and up in a couple locations in Northfield.
And then he had, if I understood, primarily shredded tires on his property. They weren't actually whole tires, but they were shredded. He was trying to do something with on his property.
I think, yes, yes. The pictures, he was engaged in shredding the tires into little strips, maybe a couple feet long. And again, he is not arguing the convictions or the wrongfulness of his conduct. He has been and to an extent still is misguided with the philosophy of the sovereign citizenship, and that is impaired his judgment had impaired his judgment through several years in the course of this conduct. The state never quantified any type of loss that the state did incur or would incur for tire cleanup. And we don't know to the extent of whether Mr. Senk and his family engaged in cleanup themselves. So there's nothing in the record to indicate that anyone has paid or suffered any type of monetary loss to clean up these tires.
Even though, kind of like in the O'Malley case, they talk about the risk of driving drunk, and that's certainly something society has a right to be concerned about. In the same here, society has a right to be concerned about the disposal of tires because of pollution risk and fire risk and all the other things, and that's why we have a statute to make sure these are done appropriately, and your client simply wasn't doing that.
He was not. He was not.
And he was convicted for this once before in Cuyahoga County or some similar type of offense?
Yes, and again, that is to state fairly our position accurately, which I think in an effort to give credibility to our argument this morning, we wanted to have that fairness, is that by relying on the PSI, putting that actually in the record, we have his criminal history with the, a few of the zoning violations and the hauling up, I think it was 2015. So, that is in the record and has been stated, and we want to be fair in that regard, that was past conduct, correct. And the court recognized that in sentencing also.
In slightly more than a minute, Mr. Pond has let me know that we're
Okay.
good at that point.
I am going to step away from the podium and ask the state to present. Thank you.
Certainly will recognize that remaining time for
Okay, thank you. All yours. Oh, that till the end. Thank you so much.
Thank you for that, Counsel.
All right, may it please the court, Sally Montel on behalf of the Ohio Attorney General's Office. Appellant has not met his burden on assignments of error 1 and 2 for essentially the same reasons. And that's because the trial court imposed a mandatory minimum fine in this case, and it was not grossly disproportional to appellant's crimes. The state asked this court to overrule assignments of error 1 and 2 and to modify the sentencing entry to remove the post-release control from assignment of error number 3. Appellant's crimes were not isolated incidents in this case, but were part of an illegal scheme that started over a decade ago. The appellant was the mastermind behind an illegal scrap tire business, and the Summit County Health Department, Ohio EPA, and Northfield Village have been following around the appellant for years from property to property, asking him to stop illegally transporting scrap tires and to stop illegally storing and dumping scrap tires throughout Summit County. Appellant, has been in this business for a long time, and at no point has he obtained any of the relevant permits, registration certificate to transport the scrap tires, no permits to shred scrap tires or have a recycling business. Appellant enlisted employees to help do his manual labor because he does have his physical disabilities. He also falsified paperwork to give to scrap tire businesses to trick them into thinking he's a registered scrap tire transporter so that they would pay him to take these scrap tires that he's then supposed to legally dispose of. And this falsified paperwork is one of the exhibits, has a notary signed, and it looks really official to trick these scrap tire businesses into giving him these scrap tires. He turns around and dumps them in several locations, one being the warehouse you talked about, and there is evidence in the record that they testified. Ohio EPA went out and did an estimate. They found approximately 25,000 to 30,000 scrap tires in that warehouse. And at that moment, they believed Ohio EPA was going to have to clean it up because the appellant was not willing to clean it up. He also dumped them on a vacant piece of property that he owns. He had big, huge mounds, this tall, of scrap tires, neatly cut up into long strips, piled up. He also put some down in the ravine at the bottom of his property where there was a creek. He put them laying over the creek. There was testimony from the neighbor of that property that he said he might have been trying to build something to drive over the creek. But of course, then what happened 2 years later after he dumped them there, a huge rain event occurred and 100 pieces of scrap tire were washed down this creek. It's a tributary to Tinker's Creek, which flows to the Cuyahoga River, then the Ohio River, and ultimately to Lake Erie. And it also piled up down at a culvert at the road there, Sagamore Road, which could have caused flooding. So some of the risks that these laws are passed to prevent actually happened in here. And his actions polluted 300 feet of creek bed in a residential area there in Northfield Village. His actions put his community and neighbors at risk because of the fire hazards involved in scrap tire violations. This plus his higher degree of culpability definitely warrant a $10,000 fine in this case.
Is the appellant correct in that there's no specific estimate or any testimony of what the cleanup cost? The state or whoever did it?
Yes, Your Honor, there is not. And yeah, you're correct. So this is not your typical Eighth Amendment excessive fines case. It doesn't involve the forfeiture of a house or a car. Here it's a rare argument that actually the fine allowed by the statutory, not just allowed, but required under the statute in this case was an excessive fines. And as we know from the State v. O'Malley case, excessive fines are those that are grossly disproportionate to the gravity of appellant's crimes. And if you reread the O'Malley case, there is actually no set list of factors or multi-factor test in determining whether something is grossly disproportionate. So we don't have to consider all of the Hill factors according to Ohio Supreme Court. But we have to look at the amount of the fine and weigh it against the gravity of the offense, which is exactly what the court did in O'Malley. And the gravity of the offense, they say, first we need to start with looking at the severity of the crime. We look at the Ohio General Assembly and how they consider the fine and its severity when they set the punishment. And here the Ohio General Assembly says, we take this crime seriously and we're going to require for a defendant convicted of these crimes to either pay a significant fine or serve at least 2 years in prison. And the court in O'Malley says that is the first place to look in the gravity of an offense. Look at the potential punishment and what the General Assembly finds appropriate. So in O'Malley, the defendant was convicted of his third OVI offense in 10 years. His truck was forfeited by the trial court, which was upheld by this court, had an estimated value of $31,000. And the Supreme Court said, again, to determine the grossly disproportional analysis, you must look at the General Assembly and give them great deference in determining the severity of the crime. The court also said you need to look at the level of culpability and the potential harms of the crime and the total sentence to determine the weighing and the gravity of the offense. And they found in O'Malley that he had a significant higher degree of culpability because it was his third OVI offense in 10 years. They said he knew the law, he knew the potential consequences, including the potential forfeiture, but chose to get behind the wheel impaired anyways. So this case has several similarities to the O'Malley case. I'm going to start with, first, that this case also involved a mandatory fine, like O'Malley involved a mandatory forfeiture of a car, which was again upheld by the Ohio Supreme Court.
If the trial court had the argument presented to them that the indigent and could not pay the fine, was the trial court's only option been to sentence him to prison in that case?
Yes, Your Honor.
If upon serving community control, he did not pay the fine, would the state be asked at that point be asking for imposition of the prison sentence?
The only way the court could do that is by calling him in and giving him an opportunity to present his inability to pay.
Well, there'd be a community control violation, and of course,
Yes.
you have to prove that. And assuming for the moment they prove that yes, indeed, he's in violation of his terms of probation, one which I assume is paying the fine. I didn't look at the record, but it would seem to me that would be one of his conditions of probation. Could the court at that point impose a sentence for failure to pay the fine?
Under Ohio law, in order to prison him for not paying that fine, the court has to give him an opportunity to show that he doesn't have the ability to pay.
And I'm confused.
Yes,
He
ma'am.
wasn't actually sentenced to prison, was he?
Correct. He was just sentenced to 2 years on community control, 90 days in jail, plus the $10,000 fine.
And how much of the 90 days was suspended?
None. I think he had credit for 23 days served.
Did he serve it so for Judge Craig's question, is he going to be required to serve the 90 days upon remand of this case?
He's already served the 90 days.
He's already served the 90 days.
Yes. He was taken into custody that day and served the remainder of the 90 days after 23 days credit.
So I guess what are they hanging over his head is what I'm trying to figure he violates community control, usually you're sentenced to prison and that is obviously suspended and you're put on community control. But here it seems like the court didn't do any of that.
No, he was advised that if he violated community control, he could be served any prison time that was allowable under law, so 2 to 4 years.
But he wasn't sentenced to that. And he had it suspended. That's fine, we'll look at it. I'm sorry.
But that is the correct statement. Under the current order, sentencing order that we have, he's done all the jail time he has to pay this fine. And at some point in time, if he doesn't, that will be a question at that point for the trial court to determine what penalty they would give him for failing to pay the fine.
Correct, Your Honor. Another similarity in this case, the O'Malley case, is the danger to society, which I think Judge Stevenson, you were getting to earlier. It doesn't have to cause actual harm. It could be potential harm to society in general and as a whole. And that's exactly what was in the situation in this case. Scrap tires are highly flammable, and once they catch fire, it's really hard to put out. And so I think it was especially troubling in this case that these scrap tires were being hoarded in residential areas and dumped in residential areas, which pose a threat to the immediate community. Plus, they cause pollution. If you do have a fire, it causes pollution to potential soil, surface water, groundwater. And if he had been a properly registered scrap tire transporter, there's a couple protections there that would have helped in this case. One being you have to have financial assurance. And that money, you have to post a certain amount of money that covers if you do dump $25,000 to $30,000. Ohio EPA would have been to pull on that financial assurance and use that money to conduct a cleanup rather than the general funds for Ohio EPA. Plus, registered scrap tire transporters have a lot of paperwork requirements. This is part of the trial court record that he would have had to keep track of all the tires he collected and where he properly disposed them. Scrap tire transporters that are registered have to take them to licensed facilities, which is exactly what appellant here failed to do, was under the cover of not having the registration certificate, was kind of secretly dumping them here and there where we could get rid of them so that he could pocket the cash. Another similarity between this case, as in the O'Malley case, is that the defendant had a higher degree of culpability. As you mentioned, Judge, that he not only had a prior history with the Summit County Health Department of Ohio EPA, who had been sending him written notifications that his actions were illegal. They had had conversations with him in person all the way back to 2012, but he also had his prior conviction from 2015. He was arraigned on illegally transporting scrap tires without a registration certificate, so we know he knew the potential penalties. He was put on community control in that case, which was, I think he served a year where they stopped the community control a year early. And then he went right back to it and started his illegal scheme again, his illegal business, and started transporting scrap tires. So that justifies a significant fine in this case, the mandatory minimum $10,000 fine. Lastly, I'll just mention his personal benefit that he gained from these crimes, which is something that the O'Malley court should be considered, is we have just from the one incident for the illegal transporting scrap tires, he obtained at least $226 from these businesses to take these tires. That's one day, a couple hours of work. And the gentleman that testified that was with him, his roommate, said that they were gonna take the tires back to Joseph Senk's house, which is in an extremely residential area. Not only did he have this scrap tire business, but his roommate testified he has several businesses, including a construction business. He also testified that he paid him rent. He paid him about $520 a month in rent. He lived with him from 2013 up until the point of trial of 2023. I don't know if he's still living with him today. That's over $6,000 a year in rent he's paid. It's not a part of the PSI here.
And I certainly appreciate there is some evidence you point to that indicate he has some ability to pay a fine. But the trial court in fact found him innocent in this matter. Is there any dispute about that?
Only when considering whether he should be appointed counsel, which, as you know, there's different standard for whether somebody is indigent for counsel purposes, whether they have the money today to pay a retainer to handle their criminal case. It's a different standard when considering whether they have the ability now or in the future to pay a fine. It's a separate analysis. these factors into consideration, his higher degree of culpability, the severity of the offenses in this case, the $10,000 fine is not grossly disproportionate to the gravity of his crime. So we ask that you, especially in light of the plain error standard, that you overrule this assignment of error. Appellate's second assignment of error is that his counsel was ineffective for not objecting to this fine. And I think I just, considering the amount of time I have left, point out that one of the reasons, in Strickland v. Washington, the U.S. Supreme Court says courts should strive to ensure that ineffective claims not become so burdensome to defense counsel that the entire criminal justice system suffers as a result. And for us to stand here today and say to a trial counsel, you failed to object to a mandatory minimum fine, and that was ineffective assistance of counsel, that was unreasonable, would shock the confidence of defense counsel and definitely disrupt the criminal justice system, especially here when there was a risk that if he had stood up and argued that the fine, his client couldn't pay the fine, there was a potential that his sentence could have been imposed. Lastly, real quick on the last assignment of error, we agree that the post-release control term should not have been included in the sentencing entry, and so we ask that this court modify itself just by striking that part of the sentencing entry. It does not have to go back to the trial court for resentencing hearing, which I have the Supreme Court decision supporting that decision in my brief. So if you don't have any questions, I'll go ahead and sit down.
Seeing none, thank you, Counsel.
Thank you.
Thank you. In terms of the third assignment of error, we were asking that a remand occur for a nunc-pro-tunct entry. I did not want Mr. Senk to go back before the court for a sentencing hearing in itself, but we would also agree that the state's proposition for that correction to be issued by this appellate court would also suffice in terms of how we're asking for relief on that assignment of error. Having said that, transcript of docket 155 was the first sentencing that was issued, first sentencing entry that was issued. That sentencing entry did not state the fact of conviction. So it was not a valid entry as a final appealable order. On Senk's first appeal, the court dismissed it for that reason. On the second sentence entry, which is transcript of docket number 175, that entry stated the fact of conviction. And in terms of the forest and the trees of preparing for a 15-minute oral argument and hitting main points, I don't recall, it's been so long since I've read the journal entries, but I know that transcript of docket entry number 155 stated the reserve prison sentence of up to 4 years for each count. I cannot remember if the nunc-pro-tunct entry did the same thing. I'm almost sure it did, but if I make a mistake there, I apologize to the court. And I had the sentencing entry that I brought over partial files, so I brought over that which I thought would be necessary for this hearing. So,
Understandable, Counsel.
Yeah,
We will check that to see that.
So,
Let me ask you this.
Yes.
Certainly, you argue in your brief why you think the fine is excessive and why that's fair by the trial court.
I tried to.
And you raise the plain error standard. Why does this meet the plain error standard? To me, I'm not sure you necessarily argue why this is such a manifest injustice that we have to correct it at plain error, not just recognize it is effective.
And that's part of the hurdle that I referred to without explaining when I first stood up and explained to the court why we were here. And I've conveyed that to Mr. Senk that that is a very high standard. But the fact remains that trial counsel did not object to that constitutional, the potential constitutional issue. Did I answer your question?
You did.
Okay, thank you very much. Have a good day. Thank you.
And thank you both for your presentations today. The court will take the matter under advisement and issue a decision in due course when that is the right. that, it'll be mailed to you by the clerk of courts and also be available on the High Supreme Court website.
Thank you.
Thank you.